Your patient, Miguel Ramos, has begun proceedings in a malpractice suit against you.
Roger, what could I have done that's malpractice?
All healthcare professionals are held responsible for their actions and to a reasonable standard of care. If the care you give causes either mental or physical harm or deviates from the standard of care, that's malpractice.
Well, what if there's only mental harm and no deviation from standard of care?
Well, then that would be called a maloccurrence. There may be other standards that are applied to malpractice suits, such as surgical errors of commission and omission. Do you think you caused any emotional distress to the patient?
Not really, but that's probably hard to measure. Okay, what should I expect with the court system?
Well, the first phase of the case is called pleading. The patient's attorney goes to civil court, files a complaint against you, and a summons is delivered to you by the sheriff. The second phase is called pretrial discovery, where the court sets a trial date for us. Once pretrial motions are made, you are subpoenaed by the court for a deposition, sworn testimony given in front of me and their lawyer with the court stenographer present. Next, both me and the attorney will meet with the judge to discuss the case in a pretrial conference. 90% of the time, it's settled at court.
What should I be gathering for this pretrial phase?
Glad you asked. I'll need all documentation of all correspondence between you and Mr. Ramos regarding this matter and his medical records.
And what happens if the suit is not settled in the pretrial conference?
Then it goes to trial. A jury will be selected. Both myself and the patient's attorney will give opening statements, cross-examine witnesses, and make closing statements. The judge then asks the jury to deliberate until they reach a verdict. The judge makes the final judgment.
This sounds like a long process.
It's very long and very costly.
Well, let's just hope they don't have a case.